Welcome to the Compassionate Capitalist Show. Thank you so much for tuning in, watching. If you're watching on YouTube or listening on your platform of choice, I am very excited about my speaker. It's been a while since we've dealt with this topic, but it's a really critical topic. We're going to talk about buy-sell agreements. And if you haven't heard of them, now you have. And if you have been meaning to put one in place, now is the time. And this is important for both entrepreneurs and investors because, the type of investors that will read my book, Inside Secrets to Angel Investing, may be people that, invest, they're a small shareholder and therefore don't have a lot of say in it, but you want to make sure if you've got two co-founders or more, multiple founders in a business, that they have a buy-sell agreement in place. If you are a silent partner in a business and the primary financer, because maybe it's a community-based business, not some big scalable business, is even more important. You have to sort of think about buy-sell agreements like a living will or a power of attorney. You don't really, that you might personally have known you needed to get, and hopefully you have those in place. And you don't think you really need it until you need it, right? And then it's too late. And so my guest today, Paul Hood, wave your hand for those that are watching, Paul, and say hello. And let me introduce him and understand why this is so important. And I apologize if I sound a little nasally. Down here in Atlanta, we got spring happening. And if you've never been in Atlanta, when it's springtime, pollen time, it can come on strong. So Paul is he hails out of New Orleans or out of Louisiana as his native state, but now resides in Ohio. And he got his law degree down there, or his master's of tax law, his undergrad down in Louisiana. I apologize, but his master's in tax law up at Georgetown. And he's an author, speaker, consultant on tax, estate, and charitable planning. He has co-authored or authored 9 books and over 500 professional articles on estate, charitable, and tax planning and business valuation. His 9th book, Yours, Mine, and Ours, Estate Planning for People in Blended or Step Families, is now out. The one we're going to focus on today, this is one of his, if you're watching, we got buy-sell agreements, but we're also going to touch on, as we wrap up, how this impacts when you've got a blended family. And anytime people are in business for a very long time, there's a good chance that there will be a situation that the family dynamics change. And so you have to anticipate that and think about that. So he's a professor has been a professor over at University of New Orleans, Northeastern, the University of Toledo College of Law, in Ohio, Northern University, Petite College of Law. So there you go. Excellent expert in the topic that we are going to have today about buy-sell agreements. So officially, welcome, Paul. How you doing?
I'm great today. Thank you for inviting me. This is a very, very important topic, and too often one that that people don't realize how important it is until it's too late.
Yeah, absolutely, absolutely. So what made you want to go into tax law? What made you decide to take your career into that trajectory?
Well, it's funny. I actually expressed an interest in being a tax lawyer when I was 10 years old. When my father, who was a CPA, introduced me to a lawyer who also was a CPA. And my dad casually mentioned that it was great that he was able to combine law and tax. And I thought as a 10-year-old, that was pretty cool. The area of buy-sell agreements, though, and the principal motivator behind my eventual expertise in a niche area of my practice was family based. When I was 8 years old, in our hometown of Alexandria, Louisiana, my grandfather and an older partner had founded a company back in 1923, and they sold seeds to farmers, and then eventually expanded the business into other areas. And by 1968, when I was 8 years old, they had like 130 employees, and it was a big business. Well, during the summers when we were out of school, um, we ate our big meals down south at noon, or actually at our house at 12:15, not 12:10 or 12:20, 12:15. But one day a week, my grandparents, Momo and Papa, would come to our house for lunch. And one day a week, we would go to Momo and Papa's house, where we were joined by my mother's brother, who worked for my grandfather at the company, and my aunt and my four cousins. So we one day, and the kids sat at a different table from the adults. But one day during the summer, there was a spirited discussion going on at the adult table. And I, of course, had big ears, so I had to listen, you know. And all I remember hearing about was Uncle Bobby got fired and Papa was getting redeemed. And that always, you know, and the next morning on the local radio station, the show that we listened to every morning, and these guys were on the air for 40 years, they were talking about it on the air. You know, this kerfuffle at Alexandria Seed. So fast forward to me going to law school, and my grandfather died when I was a junior in law school, so I never had a chance to talk to him about Alexandria Seed. And unfortunately, my uncle died prematurely of a heart attack, and I never had a chance to talk to him either.
Oh.
But when I was a brand new lawyer, I was at the Louisiana Secretary of State's office filing some documents and picking up some documents, and I had to wait for something. So while I was waiting, I asked them to pull the charter for Alexandria Seed. And usually the buy-sell language is not in the public document. It's usually if it's in a governance document, it's in the bylaws, which are private, if it's a corporation, or the operating agreement, or sometimes even a partnership agreement if it's not public. But this was 1923, Central Louisiana, and the buy-sell language is in the articles. And so I looked at it, and what it was essentially was a perpetual call by the majority stockholder at book value at any time. And unfortunately, my grandfather was like a 49% partner, and his partner, who he had deference to, was 51, even though they viewed themselves as equal partners. But they both brought kids into the business, and that's where the problem arose, because the kids had different views on the business. And finally, my grandfather's partner prevailed upon his dad to cut us out. So I started becoming I started reading and writing about buy-sell agreements, and I started drafting them, and I started getting hired to write them, and to review them and to critique them. Eventually, malpractice insurers would hire me in cases involving defective buy-sell agreements. So and that's really kind of how it started. So the book was personal. Okay.
Yeah.
The book is personal.
Well, it's really well done and very easy to understand, very methodical in how it goes through explaining that a buy-sell agreement, trigger events, nuances of things to think about that, you know, I guess that's what they pay you for, but it's like, it's one of these things where, you know, I kind of know about buy-sell agreements, but all kinds of little aspects that I wouldn't have just thought about had it not, you know, been suggested in your book, right? To consider some of these things. So let's get into it and explain to folks, because I mean, the name of it is pretty obvious, buy, sell agreement, right? But it's more than just that, because it's not just buying and selling. There's a whole lot of other kinds of things that can be covered within a buy sell agreement. So let's talk about initially just sort of by the parameters of a buy sell agreement, and in what circumstances. I kind of equated, I earlier I said like a living will. It's your directives of what you want to have happen in the event of certain things. But it's also kind of like some people might relate it to a prenup or something, because different founders or different partners, like they have different shares, they bring different things into the business. And as you said, it's different, not usually in the article. So does a buy sell agreement sort of fill in the gaps of what might be in the articles of incorporation or in a shareholder agreement, because there's other factors besides just the straight ownership in the company that needs to be addressed, and it can be addressed in a buy sell agreement?
As a matter of fact, yes. The book is called Buy Sell Agreements because that's how most people refer to them. If you go to my website though, and I have an agreement that can be downloaded, sort of a model type buy sell agreement. I always called my agreements interest transfer agreements, because obviously transfer, connotes passage by will, by gift, intrafamily sale, but actually an agreement like a buy sell agreement might cover some governance things, particularly on the financial side. Let's say your entity is a pass-through tax entity like an LLC or an S corporation, or a partnership. That is where basically you get your items of income, gain, loss, deduction, and credit, but the decision on whether you get cash to pay the tax on those items is made by somebody else. Okay. So many times in those types of entities, your agreement is going to provide, particularly to protect the minority stockholders or minority owners here, some minimal amount of cash, at least to pay their income tax. Or what they end up with is what I call phantom income, which is,
Right.
the worst kind of income you can have. So yeah, the agreement, the name really isn't fully descriptive of what those agreements typically often cover.
Yeah. Well, and it's like there also to consider, in the case of a lot of investor-backed companies, you do have multiple founders. You'll have a tech person as well as like a marketing operations person, or you might have two tech people, and then they bring in somebody that they like in some cases, like I call them execs with checks. So you get
Right.
somebody that's looking to kind of buy into a business. So they may put enough money in that gets them 30% of the company or something like that. And then they go out and raise capital. So they all kind of get diluted. So it's not a clear, this one or that one. And, you have investors, particularly savvy angel investors or angel investor groups, and even VCs in a C Corp, they're going to take first position preferred stock, right? And the whole goal is that they want to be paid out first.
Of course.
So it can get really complicated, and you have situations where, and I've seen these things where it becomes really big, famous lawsuits or you've got somebody that has a chunk of shares and then they just decide they don't want to do it anymore and they quit, but they still have those shares.
Exactly.
Right. And they just sort of walk away. And, if you don't have these kind of agreements in place, you kind of get hogtied in a way because they have a vote, even though they don't care about the company anymore. But they could, like if you want to go sell it, they could if they're still stuck there with their shares, they may, have a say in such that it influences the outcome of what happens when you're trying to create some kind of liquidity event. So let's start with talking about uh the trigger events, right? In a simple thing where it's just two co-founders, and then we'll evolve into when you have the situation I described with multiple shareholders that have a large percentage of the company. So we've got, somebody gets sick, somebody dies, there's a divorce in the family or something, there's just lots of different things where, we've seen it where all of a sudden the spouse is a shareholder and involved in the company. They don't really know anything about the company. So talk about some of those types of situations and your experiences in anticipating and helping founders and owners anticipate these things that they don't really want to think about. They don't want to think that's going to happen to them, but how to anticipate that and plan for that when it comes to creating a buy, sell, or liquidity agreement.
Sure. Actually, on my website,
Wait, sorry to interrupt you. paulhoodservices.com, PAULHOOD services.com. Go for it.
There is a tool that I developed over 25 years ago, and it was a practice tool for me. I am a huge believer in one-page things. I believe that it takes skill to express yourself on one page. And when I was a trustee of a 9-figure trust for 11 years and hired on average between 50 and 70 lawyers a year, because this trust wasn't comprised of marketable securities, it was really interest in closely held businesses. So we had real estate lawyers, corporate lawyers, tax lawyers, securities lawyers. And I would make my lawyers express themselves on one page. And of course, some of them accused me of, basically perfecting my client skills in that role. But on my website, there's something that I had developed called the buy-sell options grid. And it's basically two axes. It's a pretty simple thing. It's one page. And on the vertical axis are the triggering events. And I have probably 20, maybe as many, I haven't counted them lately. It's been years since I've counted them. Different types of triggering events. Most buy-sell agreements don't have more than maybe 4 or 5 triggering events, but I've got a whole list there. The horizontal axis is what I call the responses to triggering events, and that is in the form of a continuum, which might begin with no notice, no action, all the way to the other end, a mandatory buy and sell. And so what I would do with clients is sit down and give them each one of these grids and say, I want you to check the box. If there's a death, what do you want to happen? And they'd go down the continuum and say, well, with death, we're not related, so let's do a mandatory buy and sell. What about disability? What about divorce? I mean, obviously, most people say, well, if I get divorced and my spouse has an interest, I want the right in the buy-sell agreement to buy his or her interest, okay, or control his or her interest. Sometimes termination of employment.
Right.
And we often distinguish between cause and no cause. And I tend to divide, having grown up in a small town in the South, I'm a slave to common sense. And I divide triggering events into 2 categories, what I call good boy events and bad boy events. The good boy events are things like death, disability, termination of employment without cause. Some people have a retirement trigger where they meet a certain minimum requirement to be able to retire, and they have the right. And usually in the good boy events, the good boy or his or her representatives, if he's deceased now, control their destiny. Now, sometimes it's a mandatory buy and sell, and they just get bought out. But in others, they may have a right to cause, they may have a put right. Okay, they may have the right to say, you have to buy my interest. So that is contradistinguished with the bad boy events: termination of employment for cause, competing with the company, loss of professional license to be an owner in a professional corporation, architecture, medical, legal, accounting. And in those instances, the other side has the control. Because, I mean, think about it. And if you're competing with the company and it triggers the buy-sell agreement, you don't want it to be a mandatory buy, because the company will be, in essence, funding its competitor, which doesn't make any sense. They may have the right to buy their interest. It's a call right, though, and it's not mandatory. So these things, but clients loved it because they were able to check the box and they understood. And when we came back 3 to 5 years later to review the agreement, they ain't looked at the 40 pages in the buy-sell agreement, but they damn sure knew that option grid.
Yeah.
And they all you had to do was put that back in front of them, and their recall was instant. And it's one of the most effective practice tools. And like I said, I developed it for me. I mean, it was me to help my clients.
Yeah.
And, it's hundreds of people around the country use it because they found it as effective and easy as I did when I developed it. And it's on my website, so I certainly encourage you to look at it.
Absolutely. Sounds like a terrific tool. So how does let's do two things. First of all, how do they determine value when it comes to that at that point in time? What's the best way to determine? Do they preset what that value is going to be, or is it based off of an appraisal, or how do they go about determining the value of that?
Value is a very, very difficult thing. Publilius Cyrus in the 1st century AD said, a thing is worth what the purchaser will pay for it.
Yeah.
Which is in essence the expression of the market approach and valuation. There are 3 approaches. You've got the income approach, the market approach, and the asset approach. In a family business, there is another issue in valuation, and that's the tax issue. Particularly if the estate tax, or if you're in a state that has a death tax, whether it's in a state estate tax or a state inheritance tax, the value becomes relevant. Okay. And in family buy-sell agreements, you want to always use fair market value as your standard of value. Now, that's the tax standard of value. Some people use fair value, and the difference between, now fair value can vary from state to state in what the definition is, but as a general rule, fair market value recognizes the various levels of value, which start at the top, synergistic control, goes to financial control, marketable control. Then you go to marketable minority, which is where most appraisers believe publicly traded stocks change hands at the marketable minority level. And then at the non-marketable minority, the bottom level of value is where you have valuation discounts, like discount for lack of control, which is computed first because as you go down the level, and then your discount for lack of a market or marketability. And you mentioned, setting your value. Bad idea.
Okay.
For several reasons. First is a lot, and I call these methods the ostrich methods because it's often referred to as a Schedule A method. And y'all set the buy-sell agreement says the owners, here's the initial value, and the owners agree to revisit this and update Schedule A annually. Well, guess what? It doesn't happen.
Yeah.
People sign that agreement, they shove it in the drawer, with their old Tic Tacs and other stuff that they've accumulated, the extra ketchups from lunch that they ate at dinner, and then they don't read it again until a triggering event occurs. And then all of a sudden they're like, oh no, it's been 17 years and now we've got a triggering event and we hadn't revisited the value. So any lawyer that drafts that, I believe, is committed malpractice. I mean, I'd be real frank about that, because people simply don't update those. You say, well, Paul, that's what they wanted. Well, I don't care. You shouldn't let them because they're not going to do it. Okay. And it's reasonably foreseeable. And cases come out every year that simply prove it more and more. So value, though, is a matter of setting the rules. Who determines value? How is it determined? What's your level of value? What's your standard of value? What's the qualification of your appraiser? Another bad idea is trying to set the value by formula. As a very young lawyer, a CPA who was a major contributor of clients to our firm wanted me to draft a formula for a buy-sell agreement. And I worked my butt off all trying to capture every element of value. And you know what I determined? I determined that it was a fool's errand and that it couldn't be done. And what finally occurred to me Sunday night that weekend about 9 o'clock, because I'm still at my office working on this, because he wanted his answer Monday morning, was a phrase that I learned my 1 year in grad school. It's probably the only thing I learned other than accounting faculty at LSU at the time was dysfunctional. And which is why I went to law school, because I went to grad school with the idea of becoming an accounting professor. But when I saw how the PhD students were being used as pawns by this faculty that was antagonistic to each other and eventually broke up and scattered to the winds while I was in law school, the dean, the department chair in accounting back then, Vince Brenner, he deserved hazard pay. Okay, he really. But the phrase that I learned was, if you torture the numbers long enough, they'll confess to whatever you want them to say. And formulas can be manipulated.
Yeah.
And I don't care if you put in, we're going to use generally accepted accounting principles, and you better say consistently applied after that, because GAAP ain't as clear always, or it often offers options that can dramatically impact. So formulas are a bad idea. I just don't believe that it can be reduced to a valuation formula. I know people, love rules of thumb and things like this. And they're rough, they may be good sanity checks for value, okay? But if your ox is being gored because you you were held to a formula that generated, let's say it generated a zero value. The courts have held those up. They said, well, you signed on to that agreement. You agreed to it. And yeah, it's a silly result, but it's a self-inflicted wound.
So when you, but in the event that you have a trigger and you need to determine, this person's shares, something has to happen to them. They're going to be bought from whoever that person or their descendants or whatever the situation may be. You would hire a third-party appraisal firm and use industry standard of setting the value of the company based off of, EBITDA or customer base or equity in the company valuation that was set.
The biggest mistake and unfortunately, most lawyers don't know much about business valuation. Okay. I became an expert in it because I was dealing with high-end estates, and in estate planning, valuation is one of the four main issues in estate planning. Is it includable? Is it deductible? And certainly valuation, which is the 800-pound gorilla issue. And what you want, I wrote a book, my first national book I wrote on business valuation with a business appraiser, and John Wiley and Sons published it back in 2011 or 2010. And in preparing for that book, I read every tax business valuation case going back to the beginning of the income tax, which was enacted or which became effective March 1st, 1913. And since then, and I have read, I'm literally probably the only person in the country that has read every single case. And I boiled down business valuation because, once again, I'm just a simple guy, into three rules, and I call them Hood's rules of business valuation.
All right.
And the first rule is actual value is irrelevant. Actual value is unknown. Perceived defensible value is everything. And it's all about the evidence of value. And that's why the appraiser is so important. And lawyers, I got a buy-sell agreement on my desk right now. The lawyer drafted this agreement and asked that value be determined by the certified public accountants. Well, I love CPAs. I mean, I do work for AICPA. My dad was a CPA. I mean, I owe my life to CPA. But unless they are trained and have credentials as a business appraiser, and AICPA now offers one, it's the ABV, accredited in business valuation. There are basically four BV certifying organizations. There's another accountant group, NACVA, which were CPAs who were primarily business valuation people who got tired of AICPA not having a credential, so they formed their own organization. There's the American Society of Appraisers, which is a multidiscipline, and business valuation is just one part of it. They got people appraising art and machinery and, every other aspect, real estate. And then, of course, you've got the Canadian version too, the CBV Institute. But unless accountants have a credential in business valuation, one or more, they're not qualified to be business appraisers. And, you see this play out in divorce court all the time. I was rarely in a courtroom. Usually the only time I was ever in a courtroom was as an expert witness. But I often had to watch cases where two CPAs were the valuation experts for each side in a valuation of a business, and neither one of them knew what the hell they were talking about.
Yeah.
I mean, it was ugly. it was ugly to watch Ray Charles and Stevie Wonder playing tennis.
Dang. So, yeah. So, but there are people, there are professionals that are licensed with that. So that
Well,
should
there
be
are, and
something
you
that they
need to use
should
them.
consider
Exactly.
when they're establishing that. Now, can insurance be used to pay for this, or usually is it the individual, the other shareholder that pays, or sometimes there's a first option to the other existing shareholders to buy those shares, or does the company buy back those shares using key man insurance, or which is, I guess, kind of like a life insurance policy based on trigger events?
Well, life insurance can play a very, very important and beneficial role in, particularly in death buyouts, and it doesn't matter whether the company is the buyer in a redemption or the other owners are buyers in what we call a cross purchase. There are three types of buy-sell agreements. There's the redemption, the cross purchase, and the one I drafted almost 100% of the time, which is the hybrid. And the hybrid, it depends on the triggering event. In some of my triggering events, the company's the buyer. In other triggering events, the other owners are the buyers. Okay, it really depends. It's triggering event dependent. Okay, let me offer this to you, because a lot of times when someone sits next to me on an airplane and and they want to talk, I ask them, I said, are you in business? Yeah, I got my own business. I said, do you have partners? Yeah, we do. And sometimes they're family businesses and sometimes they're not. And I say, okay. I said, do y'all have an agreement that says, what happens if you die or you get divorced about your shares? And when they say no, I said, well, I said, I hate to tell you this, but I said, what you really have is not a company. I said, you've got a job. Said, and you don't have any way of assuring that your heirs can monetize your rights when you die. I said, you basically have a job only. You think you own something, but you really don't. Okay. But when people say, yeah, I do have a buy-sell agreement, I'm like, okay. I said, we're going to go back to your childhood and we're going to play a game. And it's the old make-believe game, What If? And it's a game I call the fire drill.
Yeah.
And here's how it goes. You pull your agreement out and you make believe that a trigger event has just happened. Okay. It might be your death. It might be your partner's death. It might be a divorce. So you take your pick. So then take your agreement and walk through in your agreement from the trigger event all the way to the sale and purchase. Who determines the price? Or first of all, does a sale have to happen or a transfer have to happen? If a sale, who determines the price? What is the price? How is the price determined? How is it paid for? Is it all in cash? Can it be a note? And if a note, does it provide security for the note? And what you will find, and I tell people this, in my experience, in about 90% of buy-sell agreements, one of two things has just happened, hypothetically. One of the parties has been royally screwed, or there is a significant ambiguity in the process of the purchase and sale that is going to cause the agreement to either be suggestive of litigation or actual litigation. And then I tell them, well, the good news is that this is just a game and it's make believe. So the bad news is that now you know that you got a problem and the clock is ticking.
Yeah. So in the time that we have left, let's roll into your new book, Yours, Mine, and Ours, the planning for your future, estate planning for people in blended or step families. How does that impact if you're in a company and over a period of time, They do, like you say, they stuck it in a drawer with the ketchup packs, but now they wake up and you've got a different family situation than what you had before. Is there provisions that can be put into like the what ifs in each situation? So it's or, you know, to anticipate that there would be this ambiguity later on because each person's or each people that are parties to the agreement, their situation has changed. Maybe they have a different spouse, maybe they have no spouse now, whatever. Maybe their children are now active in the business and they're the ones that are actually making a lot of the decisions, but they're not a party to the agreement. So address that as you know, as potential owners may, you know, be sitting here listening to this program going like, oh dear, yeah, that is my situation. What is it that they need to anticipate and think about or put in place with the expectation that the family situation is not, you know, in concrete?
Well, first of all buy-sell agreements should provide for what happens in the event of an owner's divorce. Okay. They all should. Spouses are something that I had a bright line. I was like Tevye in Fiddler on the Roof. You remember his line on the one hand, you marry within the Jewish faith, and on the other hand, there is no other hand. Now, spouses, I always made spouses be parties to the buy-sell agreement. Now, some clients push back. Of course, I practiced in a community property state where, you know, the spouse had an undivided 1/2 interest, even if they weren't a registered owner of the ownership interest. So sometimes a little easier. But even then, some people would say, "No, I do not want my spouse to even know about this." I said, "Well, you will rue the day you made that decision when he or she leaves you and sues you for divorce." They should be parties. And in fact, I fired clients and refused to move forward with clients who did not follow my advice about that. Like I said, I had a strict, hard and fast spouses are parties, so that in the event that, you know, they're one of the statistics, you know, roughly 45% of first marriages end in divorce. And the statistics get worse, and they're in my Yours, Mine, and Ours book. You know, the probability of a third marriage divorce is close to 73%. Okay. So it just goes up. The second marriage is like 60%. Okay. You should, so your agreement needs to do that. Since I last actively represented a client, because now I work with lawyers for their clients, okay, sort of behind the scenes, if you will. And I have had 3 clients seek me out to thank me for forcing them to have their spouses be parties to their buy-sell agreements, because each one of them got sued for divorce. The spouse tried to set aside the buy-sell agreement because I gave the owner's spouse the prior rights and the right to acquire. And in each case, the spouse lost. And they lost because they knew about it. They had the right to get their own lawyer, and they had time to review it. And they were just on the inside missing out.
So in that,
And
like in that
people
situation,
all, this is important. These people all sought me out after they hadn't talked to me in years for the sole reason of thanking me for forcing them to do something that in the end saved their bacon.
right. So in that situation, it was the spouse a party to it to say they had no rights, and then they had to sign off that they had no rights?
No, they basically no, they the in many cases, and in fact, in all three of the cases that these people are thinking about, the company had been formed during the marriage, so it was presumptively community property of the spouse, and he and the other spouse, and in this case, they were all women. Okay, the non-owner spouse were all wives, and they were forced to be parties to basically do a couple things. One, acknowledge the agreement, and second, to particularly to acknowledge the what happened if they and their spouse got divorced. And like I said, in each of these three cases, the divorce lawyers for the women tried to set aside the company's buy-sell agreement in court. And
Yeah, they could sue for half of that
exactly.
ownership.
And no, they were going to get a community property share, but it was subject to the control of the owner spouse. Okay. The owner spouse was in the driver's seat, and I put them there on purpose.
Yeah.
And like I said, had I not been to my principles and allowed these clients to say, well, we just won't have them sign, each of those guys might have lost because the spouse wasn't a party. But by being a party, as Lyndon Johnson used to say, you're on the inside missing out.
Yeah. So as we begin to wrap up here, I want to direct folks' attention in your book, Yours, Mine, and Ours. I thought these action steps, now this is related to estate planning, but I think it applies because of the value that, blood, sweat, tears, money, so much goes into starting and growing a business that becomes a huge part of the estate, particularly if it's a successful business. So, you say in here that your estate plan, and it's hard to think into the future, but it needs to reflect your values and intentions and produce the best results for your family, regardless of the taxes and asset allocation. Because most people starting their business, particularly if they're not one that's intending to do an IPO or some big like that, it is their retirement plan. It is their plan, or they're building it for their kids to be able to run someday in the future. So it is part and parcel to their whole family estate and their whole family planning. So you have action steps here that say, first, take a personal inventory of each of the items below: your health, relationship with wealth and assets, relationship with your partner, your children, stepchildren, and to estate planning. And which of those, I like this part, which of those stand out as fear? Which one keeps you from taking action? Because it's difficult conversation, or it's difficult to anticipate what those trigger events, because the trigger events are kind of negative. So you don't want to think that anything's ever going to be bad that happens, right? And you find yourself avoiding taking action here. Stop right now and list your what ifs. So it kind of goes to your what ifs before by answering the following questions. What if I don't take any action? What's likely to happen? That's like when people think they don't bother getting a will. I even, it's some of those basic things. And then their wishes are left to anybody's interpretation. What if I put this off and wait for another time? What's likely to happen? What if I take one small action step right now? What could happen? What small step can I take now toward my goal of having a healthy estate plan for myself and my family, which is, also what happens with the business in the event of a trigger event? What's another step I could take? And what if I took that next step? If you find yourself feeling motivated, you can write out a list of the different steps you would take now that you see it as more important. By breaking down the big looming goals, such as estate planning, into small bite-sized chunks, you'll have a greater likelihood of acting sooner, or even greater likelihood of completing all the actions towards your goals. Think about the tortoise: slow, steady wins the race. Yep. And that is it to me, as much as anybody plans their shareholder agreement, because they're going to go out and raise capital, they really need to talk about what's going to happen in the event with the initial founders, how they get diluted, and what happens when other investors come in, and all of those kinds of things. They need to sit down with somebody like yourself, go get the form off of your website, paulhoodservices.com, and go through this process. It is a difficult conversation to have in anticipating the worst case scenarios, but it's a critical conversation to have. Yes?
Absolutely. Like I said, if you don't have a buy-sell agreement, you really only have a job.
Yeah. So, well, thank you so much for being on the show. Is there anything you wished you wanted to have covered that we didn't actually get a chance to talk about in the time we had?
Actually, no. I think that put yourself through the fire drill. That's the best advice I can give you, because if you do that, like I said, unfortunately, few buy-sell agreements are well drafted. And like I said, I know this because, insurance companies, every time they call me about this, my advice to the insurance company is usually open your checkbook and settle the case, because your insured lawyer committed malpractice. Okay. They listen to me and do that, because the first time I told them to settle a case for $1 million that the plaintiff was going to take, the claims adjuster said, "Ah, you're being soft," and then after a trial, they ended up with a verdict against them of 3.3 million, and they had 5 million of coverage, so they had to pay 3.3 million. So the next time that adjuster called me, he's like, "Well, the last time I didn't listen to you, it cost me $2.3 million." He said, "So I'm going to listen to you a little better this time."
I bet.
It's just one of those things. You pay me now or pay me later. It's kind of a Ram auto filter commercial. So,
all right. So thank you again, Paul, for being a guest on the Compassionate Capitalist Show. If you found this of value, my listeners out there, please share this with somebody. Share this important information to other business owners. Say, hey, by the way, did you put this in? What did you do about this? Take a listen to this. If you've got partners in your business, if you have large shareholders that haven't yet asked this kind of thing, anticipate it, because if at some point, if you've already brought money in and you've got, folks that are owning 20-30% of the company, you need to have them engaged. What happens when something happens to them? Maybe they're not an active participant in the business, building the business, but they're an active share. They're a good chunk of equity in the company. And you need to have that established outside of what just is in the shareholder agreement. So thank you again, paulhoodservices.com. Onwards and upwards, Paul and everybody else.
amen.
Yep. And please go to karenrands.co. I always forget to say my own website, karenrands.co, to learn how we help entrepreneurs grow and scale their businesses, get the capital to do it, and how we help investors avoid the deals that stink. Mitigating your risk and avoiding the deals that stink. Thank you very much. Onwards and upwards. Bye-bye.